Should we go ahead, Dan? Yeah. So anyway, well, hey, welcome everyone. I'm glad you're here. I know a few of you, but I don't know all of you. That's for sure. But anyway, my name is Ezra Clark. I'm an attorney here in the East Valley. I've been practicing. It's kind of, when I say it, it's kind of hard to believe it, but I've been practicing for 30 years, employment law. And so the main idea I have today, or at least I think when we were planning this, is just if you have questions, we hope you feel comfortable asking any questions you have. There's a handout, which if you are here, hopefully you got. We can go through that handout and we'll go through some of the things on the board that I put up back here. Just this is kind of a big overview. But really the idea was not for me to come with a PowerPoint presentation and go through a lot of information about the law and then tell a few stories, but actually to hear what you have to say and try to answer any questions that you have. After we're done, I'll stick around and ask any questions that you may want to, ask privately or whatever, but I hope this is informative. So again, I have been practicing employment law for 30 years. By far, probably about 90% of my clients are on the business side of the table. And so it's management. And so maybe my views are a little shaped by my experience and kind of that perspective. Occasionally, I represent employees with, individual employment agreements or contracts if they get into trouble with a former employer because of a non-compete and those kind of things. Sometimes I get involved, but usually it's on kind of the management side. I typically work with people who are small business owners or who wear the HR hat in a business. So anyway, if you don't mind, I don't want to put anybody on the spot, but there's a few of you here. Would you mind just telling me who you are so we can maybe have a conversation, and then what company you're with and how many employees you have? Is that okay? Is that okay? Just so those three things. Whoever wants to start. Should we start back here? Is that okay? You were the first in, so I.
Carly Overstreet. I work for my dad's tree trimming business.
Okay.
And we also have a landscape division.
Great.
King Street Service. We've been in business for about 40 years, I think.
40. Okay, great.
And there's about 30-ish employees between both sides.
Okay, good. Yeah. So.
Jennifer Bugrini. I came from Y Electric. I'm their human resource person there. Been doing human resources for a few years, but hearing this side with the law side will definitely help clear up some things that I probably didn't know. And we have about 48, 49.
Okay, great, good. So when you hit 50, do you know what happens?
Yeah, I don't imagine.
Right. Well, do you have the Family and Medical Leave Act? Do you have the Affordable Care that can kick in?
How long at a stretch do we have to?
Yeah, we'll go through that. We'll go through that. If you want to go through the FMLA test, I'm happy to talk to you about that. So anyway, well, good. Welcome.
I'm here with LeBaron and Carol, and I'm in the employee benefits department.
Great. Glad you're here. Dana. Well, nobody else. I mean, everybody is dying to know who you are, Dana.
My name is Dana Duncan. I am with Summer West Hines. I never want to go over 50. Never ever. We are 40-ish employees. I am the janitor. I just clean up messes.
And you're self-funded.
Okay, well, very good. Well, nice to meet all of you. And so I hope you brought your questions. Dan, you're going to tell us who's online.
Yeah, we have a number of people online. A few of them have given some info. So we have Andy's Frozen Custards being represented by Beth. They have 102 employees. Jasmine is representing Western States Metal Roofing with 80 employees. We have Alice Construction is online with 225 employees. Then Eliana Sanchez is with Boda's Concrete Construction with 50 employees. Then we have Pam with Next Gen Coating and Roofing Systems with 10 employees.
Very good. So this is a great group, very diverse in terms of the size and maybe the issues that you have. So anyway, like I said, I hope you bring some questions. Please do not hesitate at any point. If we go through a few things and it triggers a question like FMLA or whatever, we can kind of stop and talk about that. So anyway, I thought what I'd do is just put up on the board an overview of employment laws that govern the workplace. And so one law is termination. Arizona has a statute, unlike a lot of states, where there's actually a statute that an employer needs to follow and be aware of if you're going to terminate an employee and avoid any kind of liability. So that's a codification. That means it's put into law of the at-will employment rule. And then there are exceptions that are identified to the at-will employment rule in the statute. The way I like to think about the at-will rule is it's kind of like a piece of Swiss cheese. You know, it's defined as much by the cheese as it is by the holes. You know, you recognize it. So there are some exceptions to the at-will rule that are spelled out right here in the statute. And we can cover those if you're interested. But a lot of times people think, well, everybody's an at-will employee, right? So we can just go ahead and terminate them for any reason or no reason at all. That's what the rule says. We can talk about that if you have questions about that. WARN is a federal law that applies to employers who are large, usually 100 or more. And it's the Worker Adjustment, Retraining, and Notification Act. So if you ever do a mass layoff, and there's definitions of a mass layoff, then you need to give them notice in advance to the employees, unless there's an extreme business hardship. You also have to give notice to state agencies, like in Arizona, it's DES, Department of Economic Security, so that they know that there is this influx of people who may be applying and would need some extra help. There's also wage and hour law at the federal level. This is FLSA, and this is going to be kind of like alphabet soup now up here, just all these numbers. But the Fair Labor Standards Act was passed in 1938. It's the law that the U.S. Department of Labor enforces. Yesterday, I was at a client's place of business, and they had a U.S. Department of Labor auditor come in and was asking for records, walked around the workplace. We looked at their posters and those kind of things. And so Fair Labor Standards Act is enforced by the U.S. Department of Labor. And they have teams of auditors that go to businesses and take complaints and things like that. The minimum wage law is what they enforce, and the overtime law. And they also enforce child records, or not child records, but they enforce records laws because you have to keep records in Arizona. Good rule of thumb is for at least 4 years. And so they enforce those laws, and then youth labor laws as well. So if you have employees of fewer than, less than 18, you need to be really cognizant of what you're placing them in, what they're doing, and are you complying with child labor laws? Question from?
Does enforcement by that organization only come about when there's a report made, or are they active in like showing up and?
They would tell you, they kind of keep their cards pretty close. They say, well, we just, we're driving around the neighborhood. No, they sometimes say stuff like that. Like, we just got a report, but 90% of the time it's a complaint. And the complaint, now I'm talking about the U.S. Department of Labor, right? It's either a complaint from a former employee, a current employee, and that's the vast majority of that 90%. And then sometimes a business competitor will call and say, hey, these guys, and you see that happen a lot when there's a lot of contract labor. In other words, an employer is saying, hey, we're going to call everybody a 1099 employee so we don't have to pay all these benefits. We know they're misclassified, so we're going to report them to the U.S. Department of Labor. And then the Department of Labor comes in. But the vast majority of time, it's a current or a former employee who feels that they weren't paid correctly. I don't see as many minimum wage investigations. By the way, in Arizona, it's $13.85, and so you got to make sure you're paying your employees at least the minimum wage for 2013. But most of the audits have to do with overtime, and was it correctly paid and calculated? Are the employees keeping track of their time correctly? And then another audit issue is always exemptions. If you're paying somebody a salary and that you're just saying, well, we pay them a salary, so they're therefore exempt, that's not necessarily the case. So we could go through that if you want to, but that's what they investigate, this Fair Labor Standards Act. Yeah.
Question about minimum wage is that the Arizona minimum wage standard, does that only apply to a certain level of employees or kind of business, or is that if you are a sole, or you have one employee, you have to pay them?
It's pretty universal that if you have an employee and you're engaged in interstate commerce, which is most employers, if you're using credit cards, telephones, internet, so forth, you need to be paying at least $13.85 to any employee that you have. There are some exceptions for babysitters, for domestic workers who, the statute spells all that out. But you should just safely assume if you have any employee, unless he's a close family member or spouse, you should be paying him that employee minimum wage.
So like a niche little restaurant, one location. Minimum wage.
Yeah, now restaurants are unique too because there's a tip credit that they can get. So you could actually pay servers or anybody who gets a substantial portion of their tips, you could give them a reduced wage in exchange for them getting to keep all of their tips. Okay, and sometimes that's a hot button issue too, because restaurants are saying, well, we're going to have all these tip splittings. They have very elaborate things, and maybe there's even kickbacks going on. And so that's what gets their attention there. So that would be an exception. There are a few exceptions to that minimum wage rule, but the vast majority of employees are covered by it, and the vast majorities of employees are entitled to at least $13.85 for an hour that they work. Okay.
Where do you find these employees that are willing to work for $13.85 an hour?
I don't know, Dan or Dina, so I don't know that. Maybe on LinkedIn, I don't know. But anyway, so this right here is the Arizona Minimum Wage Act, which we've covered. This right here is Arizona's wage and hour law that it requires that, it sets paydays, how far apart can your paydays be? What do you do upon termination of employment? It also gives employees the right, if they're not paid timely, to file a claim, an independent action, if they're not paid in full upon termination of employment within 7 days or the next regularly scheduled payday, whichever is earlier, then they can bring a claim. They can file an complaint with the Industrial Commission of Arizona, or they can file a private party lawsuit, and they'll always request treble damages or 3 times damages. So you want to make sure that when you let people go, whether they quit or they get fired, that you're paying them timely. And so if you have any questions about timeliness, there's a difference between if you quit and when you pay them and when they're terminated. So the rule for a termination is you pay them within 7 business days or the next regularly scheduled payday, whichever is sooner. It used to be 3 days, but they changed that a few years ago to 7. Yeah.
So that when an employee terminates, you cannot deduct from their last paycheck anything more than what would normally be deducted out of a regular paycheck, like their benefits. So even if their benefits should be
Right.
deducted for multiple paychecks in the month,
Right.
that last paycheck, you can't catch up for that additional premium that would have been collected. Is that correct?
Yeah, it gets tricky. You'd have to look at you're talking about a premium and a group in medical insurance premium, try to grab it. You can do that, but I would be very careful in doing that you're being fair to the employee. And do you have a policy in writing that says you're going to do that? Any deductions that you make from an employee's final pay need to be, I always say it's good to have a policy saying you're going to do that, and then even have in writing an acknowledgement saying, I understand that if I don't, for example, return my tools, or I don't return my uniform, or I don't do this, that, or the other, that can come out of my service van. Yeah, that's, yeah, but so that's the best practice. Now, an employer, if an employee steals from you and you have a good faith belief that they have actually stolen from you, then you could withhold what you believe in good faith is the amount that they took. But I would never encourage, even under those circumstances, an employer to say, well, you can withhold the entire paycheck. They stole thousands and thousands of dollars from you, so you can withhold the entire paycheck. I always say, even though those circumstances are pretty egregious, pay them at least minimum wage for the hours that they worked during that final payroll period before you terminate them. Otherwise, you could get hit with, if you're wrong, you could get into a really nasty wage dispute. If you're right, you followed the law to the letter, and you kind of wear the white hat if you try to collect or file an insurance claim or a police report or whatever. We can talk about that too. If you have employees who you believe have engaged in theft, how you handle that. There's kind of a playbook that you want to think about. But anyway, I don't want to get off track on that. But anyway, so there's also discrimination. You hear a lot about discrimination in the workplace. Title VII is a federal law that prohibits discrimination based on race, color, religion, sex, and national origin. Sex meaning gender. And that's actually been hotly contested. What does that mean over the years? So then also ADA is the Americans with Disabilities Act, ADEA, which is the Age Discrimination in Employment Act. If you're 40 or above, you're protected by that law. And that's a lot of the workforce. The statistic I saw, it said like 63% of the workforce is that age or more. GINA is a genetic information, applies more towards healthcare plans and things like that, what they can and cannot do. And then ACRA, that's the Arizona Civil Rights Act. Immigration, this stands the Immigration Control and Reform Act of 1986. That's the law that requires you, when you hire someone new, to get an I-9 form from them, and that is everybody familiar with I-9 forms? Good. Make sure you do that. And then Arizona has its own little unique law that other states, probably, if I hesitate to say how many, but I think it's at least 15 or 20 have adopted as well, where after hire, and you take the information from the I-9 form, you run it through a federal database called the E-Verify database, and you can find that at everify.gov. And then you plug their information in, and the database will tell you whether that matches their records for that employee. And in Arizona, if you have a no match, then you really do have to circle back to the employee, have some dialogue with them and say, hey, what's going on? And then if that can't be resolved, you should not be employing them. So a lot of employers.
Is there a size limitation on that for the number of employees you have, how big you are?
It's very similar to what I said on the Minimum Wage Act. So yeah, you really should plan to E-Verify everyone. I can tell you from personal experience that if you're E-Verifying, even if somebody has a false identity, in other words, they give you documents that match, but they're not the real person behind it, the Immigration Customs and Control people, they're called ICE, Immigrations Customs Enforcement, that's the term I was looking for. ICE will give you, they're not super hardcore on employers who are complying in good faith with E-Verify. So anyway, like I said, we can talk about that. I do know that there are some employers that have made the conscious decision, we're not going to E-Verify because the Arizona law is toothless, it's never enforced. Okay, so that can change, so just be aware. Then on the benefits side over here, you have ERISA, which this is a complicated tax law primarily, but it does govern benefits. The Employment Retirement Income Security Act, COBRA, that's the law that requires that you give notice to employees who are enrolled in your group medical plan after there's a triggering event. Usually that triggering event or a qualifying event is termination of employment. In Arizona, you do have a mini COBRA statute that went on the books a couple of years ago, which means even if you're not covered by the federal COBRA requirement, you do have a notice obligation under the state COBRA requirement. So a lot of times your group medical plan administrators will be able to help you through that. We can help too if you ever get stuck on COBRA. Paid sick time, that's a relatively new law in Arizona. I get a lot of questions. I am starting to see lawsuits filed frequently now. No, I shouldn't say frequently, but I'm starting to see lawsuits actually that plaintiffs' lawyers are starting to pick up on and file. It's becoming quite a routine claim that you see when there's a termination. And this paid sick time law has a lot of teeth, and we can go through that. But the bottom line is make sure that you are affording your employees some paid sick time off. For the statute says that you have to pay them 1 hour of paid sick time for every 30 hours that they work. And you can impose a cap on the amount that they can accrue in a year based on the size of your company. If you have 14 or fewer employees, that cap on how much paid sick time they can accrue is 24 hours. If they're 15 or more employees, 15 or larger, the cap is 40. Okay. So again, where employers sometimes stub their toe is they don't report to the employees on a pay stub or in a report that they get with their paycheck how much they've accrued, how much they've used, how much they have left. And so again, if you do payroll in-house, really make sure that who's ever doing that is sharp on the paid sick time requirement. If you're using, if you're outsourcing that or using a third party, hopefully they'll be able to walk you through it. But that's a requirement. We can talk a lot about paid sick time if you want. There's also a great resource that I'll mention to you for paid sick time questions. And so it's the Industrial Commission of Arizona has an FAQ, a frequently asked question publication. It is really good in trying to flesh out and give you examples of how that works. Simple in practice, but it can get a little bit tricky in the different scenarios that come up. So that's a great resource. If you Googled FAQ, Arizona paid sick time, I think you'd go right to that. And then if you have questions or problems with that, that's maybe where you want to make sure before you just assume something's right, you run it by an HR professional or a lawyer. Safety, OSHA. I did an OSHA inspection not long ago. I was actually walking around a warehouse, and it was with actually one of the directors of the Arizona Department of Occupational Safety and Health. So it was an interesting experience to do that. And they're out there too. They're incredibly understaffed, but they frequently show up, knock on your door, and get a little upset if you don't comply with their request to inspect the workplace, especially if they think there's an imminent emergency. So make sure you're familiar with OSHA, make sure you're familiar with your reporting requirements if there's a serious injury or certainly a fatality, and then keep your OSHA logs as well. Collective bargaining. Arizona does not have a large portion of its workforce that is unionized, not like some states. But the National Labor Relations Act does apply, and then to Arizona employers. And the NLRB is the National Labor Relations Board that enforces that. And they're usually pretty tough on employers when they start an investigation, and they go deep. They want to do a lot of interviewing, and it's a time-consuming process if you get an NLRB complaint that you have to respond to. So anyway, that's the horse race overview of, I didn't even go through a couple of other ones like leave, should have been up there, but I ran out of board space. But yeah, there's leave laws. FMLA applies if you have 50 or more employees who work within a 75-mile radius. And the test, I think you asked about the test, how do we gauge the 50? It's in the current or preceding year on your payroll for 20 or more weeks of that year. So in other words, if you had 20 or more employees on your payroll last year in 2022, you're covered in 2022 and 2023. And there's a look back and look forward kind of requirement there. So we can talk about that if you want. The test for coverage for the FMLA is very similar to the coverage test for these discrimination laws too. And these apply, Title VII applies if you have 15 or more. I think, didn't somebody say they have 14 employees? That maybe no, anyway. But when you have 15, these federal laws kick in. Arizona has a sexual harassment law that applies to employers that have one or more employees. So our sexual harassment, our state sexual harassment law applies virtually to employers of all sizes. The rest, the federal law, which has more teeth for remedies and so forth, applies if you have 15 or more. Okay. Question?
Yeah, so Bill from HR Gold has two questions. The first is, has there been any clarification on the differences between a common law independent contractor and the Department of Labor definition of independent contractor, which focuses on economic
Realities
of the worker on the employer rather than on the employer's control of the work process?
Okay, that's a good question. I don't think there has been any recent clarification that I know of. I will say that that's a great question. This whole concept of, are they an independent contractor or an employee? And there's tests that different entities use. They're somewhat similar, and they boil down to control. How much control is the employer or the company exerting over that worker? Who's setting the schedules? Who's setting, who's providing the tools? Does the worker have an opportunity to make a profit? And so forth. So there's a whole series of tests that are pretty long and involved. They boil down to control. And then another kind of buzz phrase is the economic realities test. But there's a test that the IRS uses for determining whether you've misclassified a worker as an independent contractor for tax purposes. There's a different test that the U.S. Department of Labor uses for purposes of minimum wage and overtime. There's a different test that workers' compensation people in the Arizona Industrial Commission use. But the bottom line is it does boil down to how much control are they exerting? What kind of skin in the game, if you want to think of it that way, does that worker have? If they're just showing up, they're earning, a paycheck just like everybody else. They're doing things that are really a key part of what that business is doing. In other words, if you provide, maintenance services, just to use an example, and you say, well, we have this guy as an independent contractor. Well, what's he doing that your employees are not doing? If it's not much, anything different, then that's a strong indication that he's a misclassified employer. She is. Are they bringing their own tools? Do they set their own schedules? Do they actually bid on jobs? That's the idea of, do they have an opportunity to make a profit or not? Think of if you're going to remodel your kitchen and you needed your cabinets redone, you'd call maybe a few people, say, hey, give me a bid. They come out, okay, we'll do this for $10,000. They're okay, that'll be cheap, by the way. $10,000, here you go. You have no idea. You don't care who shows up. You don't care if they make a lot of money or a little bit. Maybe you do, but you don't really know that. All you know is you have to pay $10,000 and they're going to get the job done. That's a true contractor relationship where they have profit margins. They have their own people that come in and do a job. That's certainly not something you typically do yourself. So think of that as a good model or a good example of helping you differentiate. Another factor on that is if it's a business-to-business transaction or an individual and a business trying to have a contractor relationship. It's not a fatal thing if it's an individual using a social security number. That happens with sole proprietorships, but more often because you have a business-to-business relationship, that means that business is doing that most likely for other people as well. And another thing that auditors do when they come in and audit, another big audit is DES. The Arizona Department of Economic Security frequently audits your payroll reports and records if you've misclassified people. In fact, that's probably from my experience where audits start the most, is because somebody gets fired or they say, hey, we don't need you anymore. They've been classified as an independent contractor. They go to DES. DES says, well, who's your employer? Okay, we don't see you on this report. Oh, well, I was a 1099. Oh, you're a 1099. That's very interesting. We're going to audit the whole company now. So that's from my experience, that is the number one scenario that triggers an audit, and it can trigger these party audits. So I don't know if I answered his question, but but I hope I did.
Good. So second question.
Okay.
Do you have an opinion whether employees terminated for refusing to submit to a COVID vaccine or booster will successfully sue employers?
Okay, do I have an opinion? Well, I have some analysis that I'll give you on that. So the COVID thing was crazy. In fact, during the 2 years of COVID, I would come home and I say, I don't practice employment law anymore. I'm a COVID lawyer. That's all I do now. And so I had questions galore on that. And so if an employer does require, is that what we're talking about? The scenario where the employer is saying, you have to get a vaccine or we're not going to hire you?
So his exact question was, is an employee terminated for refusing to submit to a COVID vaccine or booster, do they have grounds for suing?
They might. So here's the scenario. Any employer that adopts a policy that says we're going to mandate that you get a vaccine in order to work here, And if the employee comes forward and in good faith says, I have a religious exemption, or I have a disability or a medical condition that would exempt me from complying with that vaccine mandate, the employer has a duty to try to accommodate them. And so it could be weekly testing, it could be a mask, and so forth. But I will tell you, there are some industries where it's really hard to provide an accommodation for that because, for example, a healthcare worker, back, in the height of it, if they're working face to face, knee to knee with people, providing those kind of cares, and they say, well, we're not going to get vaccinated. The courts have been a lot more flexible with what an employer who's in the healthcare industry could do. But if you have, for example, I'm going to just use maybe again, sorry, I'm picking on a landscaping business, but if you have somebody who is a landscaper who's working primarily outside, they say, I have a religious objection, you really should work hard to try to accommodate that person. Maybe it's a mask, maybe it's they ride independently, they're not in a cab or close, but for the most part, if they're working outside, maybe that's something that you could work around. So the idea is the employee has to demonstrate that they fit within an exemption to that vaccine mandate. Very general rule. Okay. And there were different mandates too. I mean, OSHA mandate got shot down by the US Supreme Court. The federal contractor mandate is still working its way through the court system, but most people that observe it think it's effectively dead because that's just not a hot button issue like it was. And then the healthcare worker mandate is still out there, but I think employers are being a little bit more accommodating in terms of what they're allowing employees with these objections to do. So anyway, there was a question, I just kept going. Yeah.
We provided an incentive to get it.
Yeah, you could do that.
Instead of the other end, we just said, if you get the vaccine and you get sick, your time off is paid. You don't have to worry about it. It doesn't go against your PTO. If you opt not to, and you get sick, your time off is not paid.
Yeah, a lot of employers adapted to that, especially when the federal government gave a lot of benefits for extending the Coronavirus Response Act. That first year, you all know, you're nodding your heads, you lived it, but there were requirements that you try to, accommodate people who needed time off and pay them. And it seems like a lifetime ago, but yet such a vivid memory too. But anyway, so that's passed. But you're right. A lot of the government said you can extend those benefits if you want, and you can even differentiate, like you said. So, and I will say, a lot of employers were providing incentives, like we'll give you a gift certificate, or we'll give you an extra day off. I mean, they were trying to be creative, not just use the stick, but to come up with carrots that didn't violate the guidelines in the tax code. So, any other questions? Yeah.
I've got one that it's not my story, but it's one I heard of a decent sized steel fabrication metal director business here, where those kind of accounts, as you can imagine, they're somewhat revolving doors when it comes to hiring, especially on the more menial stuff. And they got a call from an interpretation service for a deaf person who wanted to apply to go and work out on a job site of metal work. As you can imagine, that's somewhat problematic, because how are you going to yell at the guy and say, hey, 10,000-pound beam is about to fall on your head, get out of the way. And so obviously they didn't offer him employment and didn't pursue. A couple months later, they got notice of suit saying, hey, you guys discriminated, ADA, didn't even try to accommodate this deaf guy. We have a problem with that. And so ultimately the case got resolved, they didn't pay out, but they still had to pay however many thousands of dollars to hire somebody to get the case dismissed altogether in courts.
The word you're looking for is lawyer.
So what are your thoughts? Like, how can I know there's a healthy balance of protecting employers and everybody being able to work and whatnot. What are your thoughts?
So here are my thoughts on, okay, so let me give you an overview of the ADA really quick. And then let me just give you what I think are some pointers and suggestions generally that can help any employer deal with somebody on the, especially in the pre-hire stage, which is what you asked. I don't know if people online were able to hear that, but it's a classic case of somebody's disabled. They show up, they apply for the job, they don't get the job, and then they file a charge of discrimination with the EEOC saying they discriminated against me because I was eliminated from consideration. So that's the fact pattern, common fact pattern, by the way. But anyway, so the ADA says, generally speaking, you can't engage in direct discrimination against disabled people. So for example, you have this disability, or I believe you have this disability, therefore I'm not going to hire you, or I'm going to make assumptions about your ability, and so therefore you're eliminated on that basis. So stereotyping. The second requirement is that you engage in dialogue with an employee or an applicant after a job offer has been extended and find out what reasonable accommodations will help that employee perform the job. Okay. So I don't know what happened in that case. And I don't want to really try to guess, but it was probably that either he was eliminated from consideration out of hand because they were concerned like of that scenario you described, or they didn't explore accommodations that he could have maybe had to help him, you know. So I don't know. Deafness is a real challenge, especially in some workplaces where there's a lot of stuff going on and there's a safety concern, but the duty is still there to try to accommodate. So those are the two general duties that you have. What I would recommend that you do is that you have a written job description for the positions that you're hiring for, and make sure it's good, not just garbage internet Google job description, but it's actually specific to what's that? Craigslist is better. But anyway, so get a good job description that's meaningful. Use that as a tool in your interview, and you can ask the applicants, here's what the requirements of the job are. Do you have that on your resume, or do you have those skills? Do you have the ability to perform these job functions? Okay. And that can really be a helpful way to have a discussion with people. And then again, don't just automatically assume that that person can't do the job and eliminate them, whether they have a disability or whether they have any other protected class. And then the time for engaging in dialogue is after you've extended a conditional offer of employment. You can say, hey, we're going to extend you this job offer, but we want to talk to you about a few things. We need to figure out how we can accommodate you if that's possible. And you may have other conditions like passing a drug screen or, you know, a background check or whatever. So those are the things that I recommend that you do in the pre-hire stage. And then when you have an employee who comes forward, a current employee, and says, I have a disability or I have this condition, I need some help, take it seriously, try to engage in dialogue with them about what they need. It doesn't mean that you or the employee, especially, it doesn't mean that the employee and what they say is reasonable. You can explore a lot of options with them to try to figure out what's reasonable under the circumstances. And a lot of times they don't even have disabilities. But I think, you know, one of the jokingly what people say is the ADA stands for assumed disability, accommodate. And that's kind of true. You always want to engage and err on the side of caution. But we can talk a lot about this if you want, maybe offline or so to speak. But those are some just general suggestions on the hiring stage, and then have good job descriptions, use them for employment reviews. If an employee comes forward and asks for accommodation, that job description is very valuable, and then don't shut it down, explore what would be reasonable. Okay, in the back, I had a question, and then Dan.
So often on like job descriptions, I see like must be able to lift 50 pounds, 70 pounds. Is that what you're talking about? Like
Yeah, I mean, if those are actual requirements of the job, those are some physical requirements that you can identify. And again, you know, you can even actually have an applicant demonstrate that they can do what is a job function. But again, a 50-pound lifting requirement, there's maybe accommodations that you have too. Maybe a reasonable accommodation was get help from a coworker, or use a lift, or some kind of cart or pulley to help with that. So anyway, good, but that's exactly what we're talking about. Yeah.
We just recently had a new hire not disclose a disability, and then, a couple days after starting work, after work, he had a seizure.
Uh-huh.
Is there anything like fit test we can do, because we do a lot of machinery with the tree trimming and with the landscape? Is there something to like, we don't fire him just because of it, but if we have like a third party do like a physical exam, a fit test?
Yeah, so great question. So they have a couple of things I'll address in your question. She said that they had an applicant who was hired, did not disclose that they had a disability, and now the applicant needs an accommodation, and can you ask for a medical exam or something from them to certify that? So the employee does not have a duty to disclose that they have a disability. The questions that you can ask must be focused on ability. If you start veering off and saying, well, do you have any disability that would prohibit you from doing those things? That's a violation. But saying, do you have the ability to do these things? That's fine. So there's kind of a distinction that is subtle, but it's important at the same time. If you
Did they
do,
lie about it?
what's that?
They lied.
I wouldn't fire them because they lied in that circumstance. I mean, what does that mean? You lied. You do have a disability, and I think you get into a spitting match with them about whether they're disabled or not, or if you ask the question the right way or whatever. And I don't know how you would ask them actually. If they don't have the ability to do the job, that's different. But if they didn't self-disclose that they have a disability, it's, in the application process, they don't have a duty to do that. But you can ask them after you've extended a conditional offer of employment if they have a disability or have any health conditions that would prevent them from doing the job. But that's after you've extended an offer, and that triggers the duty to try to accommodate. So
But
go ahead.
extended them an offer and they say yes, and you talk to them about their disabilities, and they don't tell you anything, and you don't ask every little question, and it comes up. Let me give you, for instance, we had an employee who didn't have a leg. He had a prosthetic leg and didn't tell anybody, no one ever noticed, and it didn't really come out until later when he needed to drive a truck with a clutch. And he laughed and said, a guy with one leg is not gonna be the guy you wanna have driving a truck with a clutch. I want an automatic.
Did you have an automatic?
I know you got a better job offer somewhere else.
No, but that's an example of where you're like, okay, do you have yeah. And the EEOC, if you said, no, dude, you gotta shift the old style way, man, just like I do. If you did something like that, they would say, well, wait a second, why didn't you accommodate him if you had all these other things?
He drove a crane.
Okay.
Am I gonna go out and buy another $250,000 crane so that he can drive it? Am I expected to do that?
Yeah.
Is that a reasonable accommodation?
No, that's not a reasonable accommodation. What could be, just again, we're using a hypothetical. What could be a reasonable accommodation would be, let's say there was a $500 piece of equipment where he could do it with his hand instead of with his foot to operate the clutch. They would probably say, looking at the volume of your business, looking at your that's a reasonable request for a simple piece of equipment like that. And that's a good example of, you do have a duty to engage in dialogue with the employee about what's reasonable, explore accommodations. A great website where you can go is askjan.org, and you plug in the disability, and it'll give you some suggestions of what might be reasonable. I go there a lot just to check things out and make sure I'm good with the advice and the way I'm thinking about things. It explains the situation. It gives what are general, not specific, but just very general accommodations. So anyway, I want to come back because I didn't finish your question. The other part of your question was, what kind of medical certification can we require? Okay, so you can, when somebody comes forward and says, I have a disability, you can ask for a doctor's note, or you can even send the doctor or the healthcare provider a copy of this job description and say, could you give us an assessment of the employee or your patient's ability to perform these job functions? I've also seen some employers send out a questionnaire that identifies specific things that they want that healthcare provider to provide. But typically the first round of dialogue that an employer would have with the employee would be, look, you've asked for this accommodation, fine, we get it. Could you have a doctor or your healthcare provider send us a note? And by the way, give the doctor this job description and make sure you discuss that. And then the doctor or the healthcare provider submits the note. And if you have questions, you can engage in some dialogue there. If you still are skeptical because you think, well, this guy's his next door neighbor, I mean, yeah, or I don't know about this guy and what kind of, objective, medical advice he's giving this guy and us, you could always ask for an independent medical evaluation that the employer would pay for, but you have to pay for it and you have to prove that it was for legitimate business reasons. There was a business necessity for that.
So do you need to start with their doctor first?
I would go through that progression. So you establish, first of all, you wouldn't necessarily have to pay for the doctor if you can get good answers, but if you're skeptical, you have questions, you're not getting the answers you want, have them sign a consent form and say, we're going to have you go in for an independent, evaluation at our lab or at this physician. And then again, that doesn't mean one is right or one is wrong. It just means you have more information to engage in dialogue with that employee. And then you can use that as additional information to see what accommodation, if any, would be reasonable.
And that's all post-offer?
That's while they're employed. Yeah.
How would you see a CYA in that situation as well? What kind of documentation would you want?
Good documentation. No, I'm just saying what you'd want. I think I have a little packet that we give to clients when they go through this process. So I'm thinking of the forms that we suggest they use. And one form would be have the employee you actually would send them an email or a memo saying we need you to get a job certification. Okay. This comes up in the FMLA too, but we want a doctor's note or some kind of explanation, and just do that in writing, saying we want that, and give them a period of time that is reasonable for them to do that. A good rule of thumb is at least 15 days. So give them time to do that, establish that in writing. Then if you have questions and you want to call and talk to the doctor, and you can do that actually, I keep saying doctor, but I mean healthcare provider, you can say to the employee, we want you to sign this acknowledgement form authorizing us to talk to your healthcare provider. And I think that's good to have a record of that. So that's a good CYA or cover your bases step. And then the next one is when you do have any kind of interaction with their doctor about the job duties, you could do that in writing and request a written submission. And then certainly if there's an independent medical evaluation, all of that stuff should be, submitted to the employee in writing saying, here's why we're doing this. And again, you'd want to deal at that step with a pretty experienced HR person or maybe a lawyer just to make sure you're saying the right things.
You can't ask any of that before that.
No, but when you say before that, you're talking about pre-hire?
We used to have in the application a medical questionnaire of, can you do this? Can you lift that? Can you do all those things? And then this was quite some time ago, we engaged a attorney to look over our documentation. And he said, no, you can't ask any of that. Is
Right.
that?
Yeah, I mean, back in the old days, and when I say old days, I'm talking pre 1990 was when the Americans with Disabilities was Act. And that was when I was just coming into the practice. You would see applications that would say things like, do you have any disabilities? Do you take medication? Do you do this? And the ADA just boom, got rid of all that. That entire line of questioning is now off limits. Now, what rather than putting all those kinds of things on a general job application about ability, I think it's just best to put that, well, if you're going to interview them or have a discussion with them, that's when you want to review the requirements of the job in that kind of detail with them. And again, the question is, do you have the ability to do the job? The question is not, do you have a disability, an impairment, or a medical condition? Do you have a bad back? Stuff like that would be
In the interview, it would be okay to ask those kind of questions.
about ability, especially.
Do you have the ability to lift 50 pounds? Do you have the ability to?
Right, but if you're talking about me sitting in an office that would push pencils and work on a computer all day, and you say, "Hey, Ezra, do you have the ability to lift 50 pounds?" You look kind of weak. No, you can't do that. Okay. I'm joking, obviously, but what I'm saying is it has to be job related. So if you have just this general question that you're always asking, like on an application, I don't like that because it needs to be tailored to the specific job and it actually has to be a job requirement of that job. Does that make sense?
The questions need to be tied to the job description.
Correct. That's why a job description is great. And it's just really easy for you to say, do you have the ability to do these things? But make sure that your list is legitimate. It's not just some boilerplate.
Get the word disability out of your vocabulary.
Right. Now, if somebody has, this is a situation that comes up a lot. Someone comes in and self-discloses, or it's obvious that they have a disability. At that point, be careful. I wouldn't probe much into that at that stage. But obviously, if there's a conditional offer of employment, that's when you can have that discussion with them in some detail. Again, and the purpose is not to find out, really, well, my uncle has that same thing. Really, what do you do? What kind of remedy? I mean, don't go there. Stay focused on job-related questions. Even when they self-disclose or even when you have that dialogue after a conditional offer of employment. Okay, you had a question and then.
Just really quick, you were mentioning healthcare professionals. Is a chiropractor considered a healthcare professional, like when receiving a doctor's note or, return to work situations like that?
I think if it's within the scope of what a chiropractor does, yeah, sure.
Okay.
I do know, I don't want to disparage any occupation or profession. Okay, I'm a lawyer up here, right? But I did see in the COVID era, some really interesting notes from clergy, or purported clergy, from all kinds of very interesting people who are doing things, like a guy who's a manager at a marijuana shop, writing notes and things like that. And so there was a test for that, but yeah, so within reason, you can be somewhat skeptical, and that may be why you trigger a follow-up question or say, look, I'm not going to take this at face value. Will you sign this little waiver that we can call and talk to your healthcare provider? And then if you're still thinking you're suspicious, then you have that default of an independent evaluation. Again, you'd pay for it, but you have that option. Okay. So, hey, we're coming. I want to answer a few more questions, but I know we're kind of coming down the back stretch. And I want to just explain this handout really quickly too that you have, but I want to answer questions, but I at least want you to walk out the door knowing what this is that we handed out. Okay.
So last question online from Jesse, she's asking, we have an LLC for each of our locations. For FMLA, do we have to have 50 employees per location?
Okay, so that's a good question. The LLC, and this is it's called the Common Enterprise Test. And you're going to have to look at those LLCs. And if they're kind of engaged in the same business, they're owned by the same people, they have the same management, same HR policies, same benefits, same payroll, then for FMLA purposes, could be different for tax purposes, but for FMLA purposes, they're going to say that's a common enterprise or that's a joint employer. And so for purposes of counting the 50 employees, we're going to aggregate that. But I mean, if they're all separate LLCs, they're run by different people, owned by different people, there's no common ownership, no common management. They just happen to have one common member among many members or owners. Maybe there's an argument, but I know there's a myth out there that, well, you just separate all your businesses. And there's reasons to do that. But for aggregating and purposes of coverage under these laws, those entities and certainly plaintiffs' lawyers are going to argue that no, that should be aggregated, especially if there's those criteria: common management, common ownership, common HR practices, common benefits, common safety policies, that kind of thing. Good question, though. Yeah.
Do too much? Like, let's say, for instance, the 75-mile rule, and you have a large workforce that is working remotely.
Mm-hmm.
And I don't know, people moved and where they wanted to live and can still work remotely. So is there anything against an employer offering FMLA? They have 100 employees, but really truly their core population, there's only 13 people
Mhm.
within 75 miles of that. How does that?
No, an employer can adopt a Family and Medical Leave Act policy or an FMLA policy that tracks the requirements of the FMLA. I mean, it's not compulsory until you have 15 or more. It's voluntary at any size. So an employer could do exactly what you're saying and saying, look, in effect, we feel like we want to give you the same benefits that a bigger company, which really we just have you dispersed, would offer. So that would be a business decision that they could make. And I will say, when I review employment manuals of businesses, one of the things I always look at is how many employees do you have? And inevitably, if they got an off-the-shelf employment policy, they have an FML or employment manual. They gotta have an FMLA policy in there. And there's nothing wrong with doing that, but they don't have to do that. And complying with the FMLA, if you say you're going to comply with it, if you say you're covered by the FMLA, I know some department auditors at the U.S. Department of Labor said, well, we're going to enforce it just like, because that's what the employee's expectation is. So I'd have to look at whether the case.
Don't just pick and choose what parts of it.
Yeah. What I would suggest is just if you're in that 40 or so range and you want to look at, adopting a leave policy that you think is right for your business, well, look at your options, and you can maybe tailor something like the FMLA, but I don't know if I just adopt it, because then you do have a lot of obligations to comply with the posters, the notices, job protection rights and so forth, keeping the healthcare benefits current during the leave. I mean, there's obligations that an employer has that you don't necessarily have to assume if the FMLA doesn't apply.
Working remotely, is there any precedents or law or rulings on if somebody says, hey, I think I want to work from home, I'm just gonna work from home now? Are you obligated to let them do that?
No, unless there's that can be an accommodation that is reasonable under the circumstances for someone who has a disability. But usually that is a temporary fix for somebody. Usually that's a short-term way you can
I
accommodate.
found that it's a substitute for taking PTO when you're sick. So if you're sick, you're gonna work from home today, but if you wanna go on vacation, that's what PTO is for. Is that, am I within my bounds to say no?
No, yes, as an employer, you can, I mean, to answer your question, really the only circumstance I can think of where an employer has to say, stop, I really need to wonder if this person should be allowed to work from home. The only circumstance is if the employer hesitates to do that, is just if there's a disability or a medical condition and it makes sense to allow that.
Even if it's a short-term medical condition?
Yeah, even if it's short-term. I think that's the fact pattern where I think where I've seen employers say that is reasonable. We will make that accommodation or adjustment. But what
I've got a cold, I can stay home, still get
if
paid,
you allow it, I'm
not
saying
take PTO?
if you allow it. But you could also say, no, we don't want you working from home for that. That's a temporary condition. We have paid sick time, and you have PTO for that. So please take that off.
You can't make them take PTO. They don't, I mean, if they want to come in sick.
Well, right, you
work from home, you can't.
Yeah, I mean,
say you
there's
have to take
there's
PTO.
pros and cons. And I mean, you could theoretically, if somebody shows up sick and you say, would like you to go home, you're obviously sick. You can do that. You're the employer, you can do that. But you're obviously disabled to go home, not working for that. You can't do that. But a temporary health condition, no, and I don't mean to be facetious, but there's a real distinction between someone who has a disability and the duty to accommodate and a temporary health or medical condition where somebody, that's a reasonable accommodation. And you're just thinking through what is reasonable under the circumstances to do. And by definition, temporary health conditions are not disabilities.
And then do you have to be consistent with,
You should be consistent. Yeah.
once you do accommodation for one, you must accommodate for.
You want to be correct. You want to be consistent in the way you administer those kind of decisions and benefits for sure. So last few minutes, I don't even know where we're at on time. I think we're actually right there. But I will just say this handout that you have is a checklist of, I divided it up into pre-hire, new hire, during employment, and then post-separation. We've actually covered a lot of these, but these are things that, these are forms, tools, these should be in your HR playbook. And so like, I do recommend that employees fill out an application form, even if they're your next door neighbor and you know all about them. I just think a good application form is a good tool to have that you can use and rely on, and lawyers love them in litigation. They always look at those. They always see what disclosures were made, if they're accurate and so forth. I think it's good to use offer letters, job descriptions. We talked a lot about interview. You do have a duty. Anyway, I won't go through this list, but I'm just telling you that these are little checklists of just things to make sure that you're doing, practices you may want to adopt. And you may think, how do I possibly comply and understand all of this? I'm trying to run my business. I'm trying to actually employ people. How can I be an expert? You really don't have to be an expert, but it's good to know what the issues are. And I hope this has been helpful. And it's also good to have, especially with the size of companies that all of you are, you should all have employment manuals that will help you focus your policies and practices and so forth. And you want a custom employment manual. There's a lot of boilerplate, but just make sure you think through all the different options and requirements that you have before you just, okay, we got one. But anyway, and it's good to have those reviewed every couple of, I think every year, and make sure you're doing things that are right on. So the employment manual, I think, is really helpful. And I think we covered a lot of these other things just in the discussion and the overview. So I'll just say thank you for coming. I'll stick around for a few more minutes if anybody wants to ask me questions, you know, afterwards. I'm happy to do that. I've got about another 15, 20 minutes. I can hang around. And then if people are online and they want to send me an email or whatever, we're happy to engage with you as well.